Hello, this is Pamela, the divorce mystic. I'm an over 25-year intuitive attorney, mediator, and coach who's integrated a spiritual practice into my businesses. And for today's time together, we're moving into part 3 of In the Best Interest, Child Custody from the Eyes of the Bench and Divorce series. As a reminder, in part 1 and 2, we discussed what is the best interest of the child's standard, where does it come from, and how is it used? And we looked at the many factors, or began looking at the many factors that a court uses when making a custody determination. And today we're moving into two factors. What is in the child's preference, if any, and what is the child's relationship with their siblings, if there's siblings involved, and other family members, such as their grandparents, aunts and uncles, cousins, and their friends, their set of friends. We're going to look at those together because they usually are. They do have elements that overlap, and so we're going to look at them together. As far as what's in the child's preference as to which parent they want to live with, in any case where you bring a child to court, it's frowned upon unless it's an emergency. So what would be an emergency? Something such as a child witnessed something, like a parent abusing a substance and there was a fallout. Maybe they passed out, they left the gas on, something bad, tragic happened, and the other parent wants to get a protective order. And so the only one who saw what happened was the child. And so in that situation, it may be excusable to bring the child to court in order to protect that child's interest, to show the judge that there truly is something that's happened that's scary to the child and it's not in their best interest. So in any other case where it's just what is the child's preference? For our hypothetical, we have a high school student. Let's say he just got his driver's license and he's in high school and he has a good relationship with his friends and he works part-time at one of the fast food restaurants. And his sibling is a 7-year-old little girl who is not so much about school, although she does okay in school. She's just not much about her friends and she's not much into extracurricular activities. She comes home and looks forward to on the weekends to go see her grandma or her aunts and uncles and their cousins, and there's a lot of family time together. And that's what's important to her. So the high school student may have a preference that he wants to stay in that school district. He's got friends there. He's about to graduate in a couple of years. He doesn't want to interrupt that. And he's working. Things are good for him. And so he wants to stay more stable. So a judge may look at that and say, that makes sense to me as to why this one would want to stay here. Now, in this hypothetical, we're assuming that one of the parents moved out of the school district. So since we're assuming that, let's move this other parent 4 or 5 jurisdictions away from the school. So it's too far for a judge to consider a shared custody schedule because it would be too inconvenient and a hardship on both children to be in this school district and have shared time in the other district. But the other district has the family. So the parent who has the larger family in that jurisdiction in which the little girl has a relationship with, they are she's moved there or he's moved there and wants the child with them. Child's preference, we can't get that into the court without losing our head in some cases, because the judges really do disapprove of bringing a child just to state their preference if that's the only reason that they're there. So, and I'm not saying that that's the case in every jurisdiction. I don't know every jurisdiction. I'm just saying that in most cases, judges are very smart and they know what they're doing. They do this every day. And in most cases, they don't need a child to tell them what's their preference, unless it's a very special case. And those do exist. So in this case, what does the child's preference, what's the 7-year-old's preference? We wouldn't know that unless one of the parents insisted that there was a guardian ad litem, which, if you recall from our discussion on a guardian ad litem would come in the case, speak with the child, see what their preference is. Look at the school, look at the extended family members, have conversations, have interviews, and come to court with a neat little package of with a recommendation. I think it's going to be in this child's best interest if that's not happening, or if a guardian ad litem has not been appointed, or a child specialist has not been appointed to give the court a recommendation, the court kind of has to get that recommendation through testimony of other people, even though it may not be admissible. But they have to read between the lines, because it's less likely that a child's going to come to court, right, and say what's in their best interest or what they would prefer. Unlike, let's say, the high school student who is intelligent, he's emotionally mature, and he's able to come in and he's not bothered by his parents' divorce. He's doing fine. He's looking forward to college and moving out and, doing adult things at that point. So in that sense, it's not so tragic to bring him to court. Not necessary. Most judges will say it wasn't necessary, but in order to get that preference suggested to a court, that's the only way we can get it in, is by bringing a witness, right? So in that case, the court may not look at it or frown at it so badly as they would the 7-year-old. Now, what is the relationship between the siblings? Well, these two siblings are close, but because they're so different, there's such a disparity in their age that they don't spend a lot of time together. In fact, now that brother has a car, he's probably never home. So the relationship between the two of them, although is a factor, it may not be considered as heavy as it would be if it was, say, a 5 and a 7-year-old. That's going to be in the same house together for a long time moving forward. There would be absolutely, the court may feel it would be detrimental if they split them up, as an example. But in this case, let's just assume that the court decides that based on this 7-year-old's relationship with the extended family members and her cousins, and she's not so much into the friends yet, and she's not so fully ingrained in school that a change in a school district would be a detriment to her, that it might be in her best interest in this family that she goes with the one who moved into the district where the family is. Unlike moving the high school student to that jurisdiction and making him switch schools would be a little bit more detrimental. So in that situation, a court may make the decision to do a split custody parenting arrangement, whereby the high school student stays in the jurisdiction with the parent who's in their school district, and the other one goes into the jurisdiction on a more primary basis with the one who moved by the family. So that's how we look at what the relationship is. It gets a little bit more tricky when one of the parents, as an example, is moving out of state, similar to a relocation case after a divorce. But let's just say in this case, the parent moved out of state and they want to take the children with them. But the high school student doesn't want to go to a new state, to a new high school. So in that case, the weight of his preference is going to be more so than the previous fact pattern. The 7-year-old doesn't have a bond with her school. She doesn't have yet a big group of friends, but moving her out of state and out of her school district might be, in a lot of judges' opinions, a little bit trickier of a choice or a decision for them. And it's not like you're moving out, into another county. Once that child moves out of the state, after a certain period of time, they lose jurisdiction over what's in the best interest of that child. So making a decision to let a child leave the state, they take that personally, because they've got to know that once they release custody or release that child to another state's jurisdiction, that whatever the time frame is, whether it's a month or 6 months or more, when that child becomes that court in that jurisdiction has decision-making authority over them. In a lot of cases, not all cases, but in a lot of cases, that state takes over. So in such a situation like that, it may be more difficult for a court to make a decision. So all of these little minute details, that's why this is in a series. All of these little minute details matter. What the facts are, what is the difference, where are the parties living, what is the current situation with the children and their siblings, their children and extended family members, where is each parent planning on living. A lot of times it's mistaken that if a parent's going to stay in the residence that the parties lived in during the marriage, and they're going to stay in that residence in the same school district, that it's a done deal, that a judge is of course going to keep the status quo and that parent's going to get custody. I hope that over the discussions, the last few factors, that you can see that it's not always the case, because although these factors seem very basic on their face, when you start getting into the multi-layers, you start seeing how one little fact can change a larger determination. And when you've got parties that are head to head, it could be one little detail that the judge uses to make a final decision. On balance, on all of these factors, either parent could perfectly take care of these children. They're both fit. There's nothing that I see that's that would be not in the children's best interest with either one. It's just not a situation where we could do shared custody, and we certainly can't do legal custody jointly, because these parties just can't seem to communicate. So I'm on the edge. I may have to do a legal custody with one parent and the primary custody with one parent as well, and come up with how a parenting plan that's going to include the other parent, but it's still going to be a primary parent with a visiting parent situation. And it might be one little minute detail that changes everything. So understanding that when you're putting your child or your children's fate, which is also, as I say, your fate, into the hands of the court, it's important to know that all aspects of your family are scrutinized. Every little issue that seems like a non-issue can be an issue, and things that are issues can be a non-issue. You never know. So it's important to know that everything that I give you or everything that I say or share with you is information and educational only, that it's really critical that you get your own legal advice from your jurisdiction, from somebody who is well versed in your particular court system, so that they can tell you what factors that particular court looks at more than others, and how they're weighed, and what do you need to specifically know, and what can you do, what should you do, and what you shouldn't do before, during, and after the trial, right? So those specific legal nuances as they apply to you, the only way you're going to know specifically is if you already have legal representation or you find legal representation in your particular area. So it's important to reiterate this in every video. So you're going to get tired of hearing it, but I'm not going to get tired of saying it, because it's truly that important. Your family is a family. It's going to continue to be a family even in divorce. It's just a family in transition right now, but it'll be a family on the other end of this. It's just going to look different. If you're in a situation where there is no abuse, if you're in a situation where you don't need the court's protection, and there is a way that you can move into a custody situation that's more holistic, there's many ways of achieving that end. But if that's the case, that you can do that, consider it. If, however, you're in the court system and you're bound to it at this point, there's no way that you and your spouse are going to be able to work things out holistically or between you without using the court as the final determinator. Try not to forget, regardless of what's going on outside of you, that you are the best judge of what's in your child's best interest. You and your spouse are. And if there is a way that the two of you can come together with just that understanding. Our family is a family. It's just in transition. It's just going to look different. But we are the family, and we, as the family and as the parents of these children, are the best ones to determine what's in their best interest. So if we can come together and do what we need to do to reach a conclusion or a resolution that's going to be maintaining the children's anchors as their parents, the integrity of the family, although it looks different, the integrity of the family is like a glue. Only you two can decide whether or not it's going to be separated. Outside influences can't do that for you. But the two of you can say, we are a family. We understand we're a family in transition. We understand that it's up to us as the parents to do what we need to do to make sure that our kids make the transition smoothly, that they see us being strong and anchored, and we're not lifting, we're not shaking the boat. We're pivoting very smoothly into this transition. Your children, that's what's in your children's best interest. So, of course, as a professional who's done this for many, many, many years, I hone in on this on any time I can, because I want to share that wisdom with you. I want you to understand how valuable you are as a parent, how valuable your spouse is as a parent. If there's any way, absent, like I said, any abuse situation, I don't want to keep having to keep saying that, so just assume I mean that. But if there's a way that the two of you can work together and just stay a team. No matter what, stay a team. Because if you stay a team and you're doing what's in the best interest of your children, then most parents do what's instinctually correct for their children. It's only in times of adversity, whether it's divorce or some other tragic situation, where they start acting in behavior that doesn't necessarily suit the situation. So know that the dust will settle, but then what? So you two can create what it looks like when the dust settles, and you can create a situation that the dust will settle sooner. And knowing that we are in an age of awakening, there's going to be many people who are divorcing. Many relationships are being shaken. And when it comes to a shakeup that comes to a breakdown, there's no reason why we can't be more enlightened and elevated in our approach in terms of how we move forward in the process of transition and how we take our children with us. So if we can put the focus back on the children, knowing that the transition is normal. A lot of people are going to be making a transition. There's no room here for shame or blame. This is what's happening. And when you know that it is your soul that is driving the ship, and you know that you're moving forward on your evolutionary journey, and you understand the higher purpose of the relationship and the relationship with your children, and that idea that it's not just a human family, it's also a soul family. If you can move with that as your guide, you don't need a judge. You don't need anybody to tell you what's right and what's wrong and what's in the best interest of your children. You guys know. So till we meet again in the next section or the next series, hold on to that. Know that all is well with your soul. You've got this. Get the information that you need in your jurisdiction. And hopefully, like I said, I've caught you before you've tipped your toe in to the litigation. But if you haven't, do the best that you can to hold that knowing. Your family is a family and will continue to be a family. And the two of you are what defines the family. Okay? Until we meet again, namaste.